Although it beats the Wild West practice of dueling on Main Street at high noon, there's nothing cheap or fun about going to court to settle a dispute. Let's face it, hiring a lawyer and litigating a grievance is really out of reach for most of us. But if you have the right case, many lawyers will consider taking your case on contingency, where they get paid only if you win, and they get paid from the winnings of the case. This video looks at contingency cases, when they're useful, and how they work. Hi, my name is Carr Ferrell. I'm a Silicon Valley patent attorney. Welcome back to my channel. So what is contingency litigation? Well, contingency litigation is a fee arrangement. It's an arrangement where the attorney and the client agree to split the winnings in lieu of the attorney's legal fees. Rules for these agreements are controlled by state law and by attorney codes of conduct and rules of ethics. Generally speaking, these contracts, these agreements must be in writing and must be entered into freely by the client. Contingency fee agreements don't work for all cases, and they don't work for all parties, all clients and all attorneys. For example, contingency fee only works if you're a plaintiff. You have to have the ability to win a case, and you must have the opportunity to win money damages as a result of winning the case. There has to be money at the end of the case to pay for the costs and the expenses and the lawyer's fees. Otherwise, there's no incentive for the lawyer taking this case on contingency. So these are cases generally that have fairly significant damage potential. It's going to be very unusual to see a case with less than maybe $100,000 or $200,000 that would make sense for an attorney to work on contingency, unless they're expecting just a very quick settlement. Even so, it's important to understand that many attorneys just don't take contingency cases. Either their law firm is too big and too bureaucratic for contingency cases, or their law firm may just be too small for contingency cases. For example, I used to take cases on a contingency basis as my practice was just getting started, but I no longer do as my practice has grown and matured. So how does a contingency case work? Well, the lawyer and the client negotiate the fee agreement. And the fee agreement can take one of several forms. There can be a full contingency case where the lawyer will pay all of the costs and expenses, including things like court reporters and court costs, expert witnesses, deposition fees, and the like. Or an arrangement can be made where the client pays for the costs in the case and only the attorney fees will be contingent. Obviously, a contingent case where there's full contingency, where the lawyer pays all of the costs, the lawyer's going to want to negotiate a higher percentage of the winnings in order to recoup those expenses. If, on the other hand, the client pays the expenses, the attorney percentage will be lower. And the percentage itself ranges often between 15% on a partial contingency case to maybe as much as 40% or even a little more on full contingency where the attorney pays the costs. And the percentage really is dependent on how large the case is, what kinds of expenses will be incurred, and also what's the likelihood of winning the case. If it's a slam dunk case or an easy settlement, often it's going to be a lower percentage. If it's a case that probably will go all the way through trial, that's going to be a lot more work and a lot more expense on the part of the attorney, and they're going to want to be able to recoup that. So what are the pros and cons of contingency litigation? Well, contingency litigation serves the social purpose of allowing people who otherwise couldn't afford litigation to have their day in court. It affords more people the opportunity to receive justice in civil cases. Another positive characteristic about contingency cases is it puts the burden of winning the case and working hard on the case on the part of the attorney. The attorney really doesn't get anything unless he or she wins the case. And so it incentivizes the attorney to work hard and to do their very best for a successful outcome. Well, there's probably no doubt that contingency litigation leads to some ambulance chasing and some billboard lawyer advertising that might not exist otherwise. Because some of these cases can be extremely lucrative, especially in the area of personal injury. We often, unfortunately, see lawyers clawing over each other, trying to get at valuable clients, especially after significant disasters. Another negative is it creates a bit of a perverse incentive for the lawyer to settle the case as quickly as possible. Now, the client always gets the final say in terms of when a case actually settles. But the sooner that a contingency lawyer can settle the case, and the less work that they have to do to get the case settled and to get funds dispersed, the larger the return on the investment of the lawyer. So there is obviously going to be an incentive for the lawyer to try and settle this case just as quickly as possible. So how do you find a contingency lawyer? Well, the most important thing is to start with finding a good lawyer. And I have a video that I've done on this, and I'll put a link to it at the end. But it's important to find a good lawyer first. Don't think of it as a contingency lawyer, but find a good lawyer. And we do this by checking with referrals, checking with friends, checking with business colleagues. Look for lawyers that they've used in the past. Word of mouth, personal referrals. These are the best ways to find lawyers. You want to find someone you feel comfortable with, someone that you feel confident with, someone that's going to communicate with you and communicates clearly and communicates often. Once you get some referrals and find some lawyers that you like, discuss with them the possibility of contingency representation or some form of alternative billing. Many lawyers will be open to this, especially in smaller firms where there's a little less bureaucracy. But there are a lot of lawyers who work on contingency, especially if it's a good case. And on the flip side of that, if you're having trouble finding a contingency lawyer, or you have lawyers, good lawyers, who are refusing to take the case on contingency, you may want to take a closer look at the case. It may just not be that good of a case, and maybe you should reconsider litigating at all. I surprisingly frequently get calls and emails, usually from individuals who are asking if I could sue Apple or Google or Microsoft on a contingency basis for some perceived social injustice, like having had one of their social media postings removed or had their account closed. I want to emphasize here that litigation is hard. It's not that unlike the Wild West, a street fight. It's difficult. Nobody likes litigation. It's expensive. It's distracting. It wears you down over time. It never goes fast, and the longer it lasts, the less enjoyable it becomes. So avoid litigation to the extent that you can. But if you need to litigate and you can't afford to litigate, contingency litigation might be an option worth investigating. Okay, that's really all I have to say today about contingency litigation. If you have some comments or some other questions, put them down in the comments section below. We'd love to read your comments. Thank you so much for watching my video and staying to the end. I'll see you next time.